Hello, my name is Jake Teege. I'm the co-principal at Fairmont Junior Senior High School. We are happy to have the school districts of Martin County West, Truman, Martin Luther, Grenada Huntley East Chain, Blue Earth, and Redwood Falls with us today. At this time, would you please stand if you are able as members of the American Legion Post 36 and VFW Post 1222 present our colors.
Prepare to post colors. Post! Underguard, dispatch.
You may be seated. It is my privilege to introduce Judge Michael Krushinsky of the 5th Judicial Court. Judge Krushinsky has served on the Minnesota District Court bench since 2018. He received his Bachelor of Arts degree from the University of Minnesota, his Juris Doctorate from the University of North Dakota. Prior to his time on the District Court bench, he served as an associate attorney at the firm of Gieselman EPA and assistant county attorney. He also served as a law clerk to the Honorable Thomas McCarthy in the 5th Judicial District. Judge Krushinsky is chambered here in Martin County District Court in Fairmont. Please welcome your District Court Judge, Michael Krushinsky.
Me? Yes? No? All right, well, I'm going to talk loud and so everybody can hear me. First of all, welcome to students from our host school, Fairmont Junior Senior High School, students from area schools here as special guests today, as well as the faculty, dignitaries, and court staff who have joined us this morning. A special welcome to those of you who may be watching live via the Gemini Studios broadcast. Many of you have been studying the court system and have had a chance to talk to attorneys and judges who recently visited your school. Minnesota's court system is more than 150 years old, older than the state. The court system is divided into 3 levels. First is the district court, which is where I work here in Fairmont, where most cases begin. The district court handles everything from traffic tickets to murder trials. There are 10 judicial districts in the state of Minnesota and 295 judges. The Court of Appeals, there are 19 judges who hear on the Minnesota Court of Appeals who hear appeals from the district court, and then there's the Minnesota Supreme Court, Minnesota's highest court, that has 7 justices. Minnesota's courts handled approximately 1.3 million filings in 2018. The Supreme Court, which is Minnesota's court of last resort, decides about 150 cases a year. How does a case get to the Supreme Court? Well, the Supreme Court hears appeals from the decisions of the Court of Appeals, the Tax Court, and Workers' Compensation Court of Appeals, where this case originates. The Supreme Court automatically hears appeals of all first-degree murder convictions directly from the district courts. It also hears legislative election contest disputes. The case you are about to hear today is the case of the State of Minnesota Respondent versus Savante Maurice Townsend appellant. Case number A1-18-0792. In 2017, Savante Townsend was charged with simple robbery under Minnesota Statute 609.24. An employee at a liquor store reported to law enforcement that Townsend concealed bottles of liquor in her bag and attempted to leave the store. But when she was confronted by the employee, a physical altercation ensued, and Townsend relinquished the bottles of liquor. The case proceeded to a court trial, and the district court found Townsend guilty. The Minnesota Court of Appeals affirmed Townsend's conviction, concluding that the phrase "carrying away" in the simple robbery statute means the act of moving personal property from the location of the taking. On appeal to the Supreme Court, the issue presented is whether the Court of Appeals directly interpreted the language of the simple robbery statute. This case was originally heard in Hennepin County District Court. Now, it's important to remember that the case you are about to see is very real. Very important matters will be decided here today, and it is critical that the justices and the attorneys are not distracted. Therefore, we ask you to abide by the very same rules you would if you visited the courthouse to see the case. Any activity that distracts the court process will be grounds for removal from the Performing Arts Center. Keep in mind the total time for oral arguments is about an hour, and we will give everyone time to stretch right after the arguments are completed. It is now time to convene court in the Fairmont Junior Senior High Performing Arts Center.
The state of Minnesota. Ms. Nelson, you've reserved 5 minutes for rebuttal. You may proceed when you're ready.
Good morning. May it please the court, counsel. I'm Julie Nelson, and I represent the appellant Savante Townsend in her appeal from her conviction for simple robbery. The issue before this court is one of statutory interpretation. Does the plain language of the simple robbery statute require the state to prove that a robber's use or threat of force overcame another's resistance or compelled another's acquiescence in the taking or carrying away of the property? The answer to that question is yes. That is how the statute reads, and that is what the legislature intended. Therefore, because Ms. Townsend did not overcome the store clerk's resistance or compel his acquiescence in the taking or carrying away of the liquor bottle, her conviction for simple robbery must be reversed.
Counsel, how do you define overcome in this instance?
Using the plain language of the dictionary definition, essentially. If we're going to look at the plain language of a statute, this court will look first to the dictionary. And American Heritage Dictionary says overcome means to defeat another in competition or conflict. To compel acquiescence is the combination of compel, the definition of compel, and acquiescence. And it means to cause or bring about by force or threats a person's passive assent or acceptance. And that is the first thing that we need to determine here when we're looking at statutory interpretation is the language of the statute to determine whether or not it's ambiguous or unambiguous. A statute is unambiguous if the legislative intent is clear from the state's plain language. And again, we look to the rules of grammar and the common and approved usage of the words.
Counsel, if I may, if we adopt your interpretation that in essence you have to have been successful, your client had to have been actually successful in taking the liquor, how do we square that with Solomon, for instance, our Solomon decision, which tells us that the taking and carrying away, even if it's only temporary, if you get it, if you have it for a moment, as she did, as your client did in this instance, that's sufficient to satisfy the simple robbery statute. How do we square those?
Okay, a couple things, Your Honor. First of all, I am not arguing that because she did not successfully get away with it that she's not guilty. I am arguing that she was not guilty because she did not overcome the clerk's resistance or compel his acquiescence in the taking or carrying away.
But what's the difference? That seems to me to be slicing the onion pretty thinly, because they seem to be the same thing to me, effectively.
Okay, and here's why it's not. And first of all, I'm going to take out the taking language, because I think we can all agree that she took the bottle of liquor off the shelf. So I'm just going to talk about carrying away today. But in Solomon, what happened was the robber went in and held a gun to the clerks at the clerk and said, "Give me the cash drawer." The clerk gave the robber the cash drawer. At that point, the robber had compelled acquiescence in the taking. Okay? And then if he took a step or two away, he carried it away as well. He was not successful, however, because he saw the police outside, dropped the cash drawer, and ran. His voluntary dropping of it did not stop the completion of the simple robbery that had occurred after he had taken it from the clerk. And this, in Solomon's, a little bit of a weird case, because he was charged both with aggravated robbery as well as attempted aggravated robbery. But this court found that based on the facts of Solomon, that he could have been found guilty of aggravated robbery and not just attempted.
Counsel, I'd like to ask you, and I'd like to ask opposing counsel this question as well, about the intersection of this case and your proposed interpretation of it with the attempt statute. Because I think you argue in your brief that this may leave us with really nothing that is an attempt statute. So I'd like to have you address that point, if you would, please.
It's exactly correct, Your Honor. That is the problem with reading into the statute that to overcome or to compel means in order to. It basically reads in, you can just attempt to use force to commit this robbery, and assuming that, and that's sufficient. And that's not what we're talking about here. The definition of attempt is the intent to commit a crime and taking a substantial step towards doing so. That's what we have here in this case. She certainly intended to rob the store, and she certainly took a substantial step towards doing so. So she attempted it, but because she did not overcome or compel acquiescence, she did not complete the robbery.
So I think you're probably right that the interpretation the state would urge here limits the reach of the attempt statute, but it may not occupy the entire field. So, for example, couldn't you have someone who actually makes an attempt but doesn't complete it, or does it in fact completely occupy the field?
It doesn't completely occupy the field, but it certainly does limit it substantially. In which scenarios you would attempt a simple robbery.
Counsel, one problem that I have with holding that an actor must use sufficient force to actually overcome a person is that it seems like we're shifting the focus from the conduct of the defendant to the conduct of the victim. Because you could have a defendant using the same amount of force with victim A. Let's say the defendant grabs the person's arm to get the purse. And the victim thinks, my goodness, I'm just going to give my purse because I don't want to get hurt. And then you have another victim who's thinking, there's no way a person grabbing my arm is going to get my purse. I mean, it seems odd to me, and I think under the definition that you're proposing, that could be a different result, despite the actor doing the exact same thing.
It could be a different result, but looking at the entire event and looking at how a victim responds is not new. For example, recently this court decided in state v. Rogers, which came out this year, that for the first-degree burglary statute, the victim must be present because we have to see whether or not they perceive the weapon as being dangerous. So we don't necessarily say, well, we're not going to look at what a victim does or how they respond. Also, frankly, if you do decide it my way, it would disincentivize any victim from trying to go after and reclaiming property, because if they don't overcome or compel acquiescence, then they're guilty of an attempted robbery, a simple robbery, whereas they actually just say, okay, fine, you've compelled my acquiescence, now they're guilty of a simple robbery, an actual simple robbery, a higher level offense than just an attempt. So I think we need to look at the entire event.
Counsel, I just want to ask you about the facts. So, and why the facts, I mean, even if we adopt your interpretation, why isn't the evidence sufficient here? And what I'm getting at is the attempt to bite, where your client said something to the effect that I'm going to bite you. And in response to that, the employee backs off. And as a result of the threat to bite, then your client's able to advance some distance away with the vodka bottles. So why isn't that enough, even under your definition?
Okay, a couple of reasons. First of all, physical release is not the same thing as compelling acquiescence. If we look at the different definition of compel acquiescence, what are we talking about? Again, we're talking about bringing about a person's passive assent or acceptance by use of force or threats. What happened in this case? Clerk's got Ms. Townsend up against a wall. She threatens to bite him. He recoils. That's what the district court found. He testified, I let go. Letting go is not the same thing as assenting to her carrying away the liquor bottles. And we know this for a couple reasons. First of all, he didn't testify that he had been overcome or that he acquiesced. In fact, what he testified to is, I re-engaged her. And when they were leaving, what was his frame of mind when they actually got out onto the sidewalk and they're still doing the tug-of-war over the purse? What is she yelling? She's yelling, let me go, let me go. And what does he say? He says, not until you give me those bottles back. So his frame of mind was in no way, I'm letting you go, I acquiesce, you can just carry these away. The district court also never made a finding that he was overcome or that his acquiescence was
But how
compelled.
far away does your client, how far does your client have to move the vodka bottles in order to have carried them away?
Well, according to the Court of Appeals, and I would say that the legal definitions comport with it, a few steps. But we're not talking about or any
Didn't that
distance.
happen here? Didn't your client, after your client threatened to bite the employee and the employee essentially does this, didn't your client walk at least a few steps with those vodka bottles?
But she didn't overcome or his resistance or compel acquiescence in that carrying away.
Because of what the employee did later?
I'm sorry, excuse me.
Because of what the employee did later.
Immediately thereafter, yes. We need to look at the entire event to determine what happened here. I also think what's really important...
Can I just ask one more question on that?
Please.
What do we make about the district court's order where the district court only talked about one bottle and didn't talk about the other bottles? So the findings that the district court made didn't have any discussion of kind of the getting of the additional bottles in this case. And so does that help or hurt your claim? How do we deal with the fact that the district court didn't get to that issue?
You mean in terms of the bottles that were taken out subsequently?
In a written order, they don't.
Okay.
Yeah.
So the facts here aren't in dispute. I don't think either party's arguing that the district court made any erroneous findings. Certainly the district court did not make particularly thorough findings. And so,
Well, it made no findings about any bottles except the one that fell on the ground before she tried to walk away.
but this court can look at the rest of the record, the rest of the trial testimony to fill in those blanks. Or alternatively, I guess, make the decision on what does it mean to overcome and send it back, remand it for further findings after this court rules. One of the things I would really like to focus this court's attention on, though, is the language of the statute. Because the middle of the statute, we talk about force to overcome the person's resistance or powers of resistance to or to compel acquiescence in. That language is really important. It has to have meaning. Here's my question.
Counsel, before we go there, can I ask a question about
Yes.
the injuries that were caused to the victim? How does that interplay with the argument that you're making? The sprained ankle, the torn shirt, the ripped off necklace?
I don't think it has any bearing on this argument. It's evidence that there was a physical altercation, he was injured, but I don't think that shows that he necessarily he was defeated or that he acquiesced to Ms. Townsend's taking away of the liquor bottle.
So what if we change the facts a little bit and let's just say that the employee chased after the defendant, but the defendant then swung the bottles and knocked the knocked the victim out, but the defendant then dropped the bottles and didn't take them any further and left the scene. How would that impact your argument?
Then she's guilty of simple robbery because she has overcome his powers of resistance. And this is exactly what the committee comment talks about. The committee comment talks about two different ways of a simple robbery: using using force to either knock the victim out, as you said, and take a wallet. That would be his powers of resistance were thereby overcome. Alternatively, the robber might throw the person up against the wall and take his wallet, and in that instance, the force was simply used to overcome resistance raised. Then when threats are being used and not force, that might be a situation where we're talking about holding a gun to someone's head and saying, give me your wallet. You haven't used force, you used the threat of force, and now you've compelled acquiescence in the taking of it. And this language, this whole idea, this committee comment, everything in there is so important because that's what they talk about in the statute itself, is this language. If the state's interpretation is allowed to, if this court adopts the state's interpretation, then all of this language basically becomes redundant. Think about it. Why would someone use force for a simple robbery? They're going to use it to overcome someone's resistance, they're going to knock them out, or they're going to compel their acquiescence. What other reason is there? So if you're going to say they use the force in order to do one of these things, it makes that language redundant.
Counsel, you're talking about comments to the criminal code that were made by a committee in 1963. What weight should we give to the comments of the committee? I mean, doesn't the statute speak for itself, and isn't our ordinary rule we just look at the statute, we don't look at the legislative or other history?
Yeah, right. Your Honor, you do look at the statute itself in the plain meaning, and if this court finds that it's ambiguous, then you certainly can look at the comments.
Then we look at the comments,
Correct.
But we first have to determine the statute's ambiguous.
Correct. But I still believe that the comments here give us some insight into what that language means. And if it means in order to, then it makes all of that language completely redundant and superfluous, and you could just simply say they use force then.
Well,
why not take all that out?
If you're invoking the comments, then I think you're telling us the statute's ambiguous. Can you tell us what words in the statute are ambiguous?
Okay, I am not saying that the statute is ambiguous. My position is that it is unambiguous. So I will, if I can, I'm simply using that as, if you find it ambiguous, here's where I would turn you to. But I believe that the language of the statute and looking at regular grammar, again, would simply say that if you make this say, if you say to overcome means in order to, one, you're adding words to the statute, which we don't do, and two, you're making that language redundant and unnecessary. And again, we don't do that. We want to give the legislature, statute's language, all the statute's language meaning. And it doesn't if it means in order to. Why would a person use force in order to do one of these things? Well, of course they are. So in addition to that, really look at that language. It's not just to overcome the person's resistance, it's or the powers of resistance. Why does the legislature care whether they simply overcome resistance, in a brawl, or whether they knock them out? What difference could that possibly make if we're just saying they did it in order to? The only way to interpret this statute is to say that they had to overcome. They had to compel acquiescence. Actually, Justice Hudson, I want to get back to a comment you had made, and I did not fully answer your question. You had talked about how in other cases we had, this court has said that it's only a moment of taking holding property or moving it just a short distance, and isn't that sufficient here? In this court has made those holdings. But that's not what we're talking about here. We're not talking about whether or not it's a moment to overcome or to compel acquiescence, unless that's what this court is going to hold. But this court's prior holdings on that matter, and this matter has not been decided. So we've only decided it in terms of taking and carrying away. It has not been decided how long someone must have their resistance overcome or their acquiescence compelled. And I would say, based on the definition, American Heritage Dictionary.
Well, counsel, on that point, do we need to decide that, though? That seems to be an empty spot in your argument. It's begging for some resolution. Don't we need to decide that?
I would say yes. That's part of what this court will be making a decision about, is what does that mean? What does it mean to overcome? What does it mean to compel acquiescence? And according to the ordinary definition of it, it's to defeat. To defeat.
So does that take you back to your discussion with the chief, that even though once your client said, I threatened to bite the employee, he then recoiled briefly, but you're saying because he later re-engaged that we don't look at the first recoil?
Absolutely, and it's not just later, it's immediately. He immediately re-engaged her. He simply repositioned himself within a brawl. Letting someone physically go and re-engaging them is certainly not acquiescing to the taking of the liquor bottles. Now, he sat down and said, go ahead, then we would have acquiescence.
But counsel, Solomon says, even if, Solomon would say, I think if you applied it directly, is that when he let go for that moment, your client had possession of the liquor bottle, even if it was for 10 seconds or 15 seconds or 30 seconds, and that's enough. That's enough under the simple robbery statute.
But the Solomon dealt with taking. So it was the taking of a cash register or cash drawer. This isn't taking. Townsend took the bottle off the shelf long before she engaged with the clerk. There was no force or threat of force in the taking. It's only whether or not she did it in the carrying away. And the carrying away started as soon as she moved from the liquor store shelf and started to move out. Now she's carrying it away.
But the statute says it can be taking or carrying away.
Right. But Solomon talks only about taking, and that's why I don't think Solomon is controlling here. And I agree in Solomon that Solomon was a simple robbery, a completed simple robbery, even though the thief did not get away with the cash drawer, even though he gave it up when he saw the police. Same thing would be true here. If she had gotten the purse and she had overcome him and turns around, there's a police officer and she drops it, she's guilty of a simple robbery. What we have here is an attempt. So I would encourage this court, again, I want to look at the language of this statute, to overcome the person's resistance or powers of resistance to or compel acquiescence in. I do believe that becomes redundant if we say that this is in order to, for the purpose of. Why else would they use this force? What other reason is there to use this force?
Counsel, let me ask one other question about some of our prior case law. I think it was the Gatlin case where we affirmed a simple robbery where the victim goes after the individual. Maybe it's not Gatlin, but there's some cases along that line. That would seem to be more in line with what the victim did here, according to your theory, because he re-engaged.
Say that again, please. I'm sorry.
I guess what I'm saying, your position with the chief was, well, because he re-engaged, the victim re-engaged almost immediately, there was no acquiescence. But we have some case law, and again, the name of the case is escaping me right now, where the victims give chase or continue. They're more involved, much like the victim was here, and we've held that that's still simple robbery.
I guess I'm trying to remember what case this would be, so I'm struggling with.
Maybe it's the Brown case where the victim laid himself over the driver who was trying to get away with, I think, Similac.
Thank you, and Your Honor.
Thank you, Justice Shudich.
That's from your days on the Court of Appeals, I believe. I apologize. Yes. In that case, the clerk took some baby formula from, the robber took baby formula from the clerk and then got into his car and was driving off. I actually believe that was an incorrect holding, to be honest with you. I do not think that was proper because he did continue the resistance. He did not overcome them. That was improper. That should have been an attempted. I disagree with that holding.
What about, it seems like providing a harsher punishment when any force is used, whether it's effective or not, probably best protects the public, which I presume the legislature in making these gradations was interested in doing.
I think that the legislature was interested in making it a felony if they actually overcame or compelled acquiescence. Use of force does elevate it, but that use of force has to do something. And if it doesn't do anything, then we're basically at a theft and an assault. And so to get to the felony level, there has to be more. That's what this statute says. There has to be more. There are no further questions. I'm going to yield the rest of my time.
Thank you, counsel. You have 5 minutes for rebuttal. Mr. Schmidt.
May it please the court, counsel, John Schmidt, Assistant Hennepin County Attorney, and Certified Student Attorney Jolena Zabel on behalf of the state of Minnesota. The plain language analysis in this case gets very complicated if we get in the weeds of the grammar, but taking a step back and looking from a 50,000-foot view to look at the context with the other theft crimes and declaring, even if the court were to declare the statute ambiguous to determine the legislature's true intent, this analysis becomes much easier. Now, whether we're in the weeds or whether we step back and take a broader view, either way, this court should affirm. In my brief, I commented on the grammatically diagramming a sentence and about determining the plain language, and this was not meant to be a slight on opposing counsel or her analysis. This was simply noting that if we go this deep into the weeds, then perhaps the statute is not unambiguous. Because this deep in the weeds with this level of grammatical analysis gets extremely complicated, and I'm not entirely sure that in 1963 the legislature was thinking about adverbial infinitives. But nonetheless, the legislature, in my view, is intending to advance and when drafting a statute, the legislature is drafting it for all the citizens in the state of Minnesota.
So let's take the 50,000-foot analysis that you've suggested, and let's go to the question I posed to your opposing counsel here. Have we so circumscribed attempt crimes if we adopt your interpretation? I don't think we can say, as I said, that it's occupied the field, but is there really much left of an attempt if we buy your argument here?
No, there is still left of an attempt because it's specific to the facts of this case. The moment that the clerk let go, that is the completed crime of simple robbery. And the map of this store, at least of what was submitted at trial, was hand-drawn and not great. But when you walk into the Trader Joe's, the entrance to the grocery store is in front of you, the liquor store is on the side. There's a long hallway that goes out from where the liquor store is located to get to Excelsior Boulevard. That's where this scuffle ended, is on Excelsior Boulevard. So it continued from the liquor store down this hallway onto Excelsior. And at some point in that hallway, Townsend said, "I'm going to bite you," and actually tried to bite the clerk. And at that point, the clerk let go. In that moment, that is a completed simple robbery crime. But again, stepping back.
So, counsel, in your view, then, it doesn't matter that the clerk re-engaged only moments later, according to your opposing counsel. In your view, that's irrelevant.
That is irrelevant, yes. And it's irrelevant because this goes to what Justice Chudich had commented on, that this becomes a very victim-focused analysis. And that also can't be what the legislature intended by drafting this statute. If we get into that, then we're looking at what is in the cage match of a simple robbery, who's going to be the victor.
So going back to my question then, pre-threat to bite, that was an attempt?
Correct. Yep. Before the threat of force at that point, actually even before that, she had yelled to her friend, "Get the mace." So arguably there's a threat even before that. But then the pre-mace comment, pre-said, "I'm going to bite you," and pre-trying to bite you, at that point there's no use of force involved, and it's a scuffle, and had she, at that point it's an attempt. Once he recoiled and let go, according to Solomon and the other cases, that is a completed simple robbery crime.
But does the defendant have to do something after the employee lets go? Or is it enough that the employee, doesn't the defendant have to move in some way so they're carrying away? I mean, would it be an accomplished crime if so the employee's pushing the defendant against the wall, holding her there, and then the defendant says, "I'm going to bite you," and so the employee lets go, but the defendant doesn't move. The defendant just stands there for a couple seconds, and then the employee re-engages. What have we got there? Do we have robbery or not?
Yes, and because based on this court's case law, the use of force can be preceding or during. The taking away occurred as soon as she put the bottle in her purse and walked past the point of sale out of the liquor store. So she's already took the bottle. She's carried it away from the place where the bottle was out past the point of sale into the hallway.
But there was no force or threatened force in the taking.
No, but the force and the threatened force then occurred within that single behavioral incident going forward, where she then threatened force as she's continuing to try to carry away. He lets go. According to Solomon, even a few seconds is enough. She had control and dominion over the property, even for those few seconds that he let go. That's where the crime was completed.
So in your view, the defendant doesn't have to move at all?
Well, the defendant
with the bottles after the employee lets go?
After the employee lets go, no, because she has control and dominion. But I think the facts in this case do suggest that she did actually move after you let go, because they are going down that hallway from the liquor store to Excelsior.
Counsel, you've said that we shouldn't be focusing on the mind of the victim, we should be focusing on the mind and actions of the perpetrator. So let me give you a hypothetical situation. I'm walking down the street with my briefcase and a guy comes up and grabs it. And then he starts walking away with it and says, "Don't resist me as I carry away your briefcase. If you do, I'll shoot you with my finger." Has there been simple robbery?
Well, at that point, the finger is not a threat of force. I mean, that
it is in his mind.
I suppose it is in his mind. I
so
don't
has he
know.
committed simple robbery if
think
the focus is on the perpetrator?
I would, in that scenario, I would say no, because it still has to be reasonable under the circumstances. And so if you're looking at what is a reasonable threat of that defendant in that circumstance, pointing your finger at somebody and said, "I'll shoot you with my finger," that's not a reasonable threat.
Well, it doesn't say reasonable. It just says uses or threatens the imminent use of force.
And that's not an imminent use of force in that situation.
It objectively is not.
No. Okay. When you're pointing a finger at somebody and said, "I'll shoot you," there is no imminent use of force in that scenario.
What if instead of a finger, it's a squirt gun?
Still probably not an imminent use of force. I mean, I suppose with a simple assault, you can assault somebody with a squirt gun, but it's more likely if he says, "I'm going to punch you," well, then we have an imminent use of force.
What if he says, "I'm going to spit on you"?
Again, that's
an assault, isn't it?
Yeah, that gets to be a lot closer, and that could be a simple robbery.
What about the initial grabbing of the briefcase?
Sure.
That use of force?
Right. I mean, that is part of the analysis. When you go up and you grab a briefcase from somebody, you grab a purse from somebody, then you are using force to take that away from the person in order to get away with it. And this is where, in the context of the other theft crimes, it's important to look at the broader picture, because if we look at the theft to simple robbery to aggravated robbery, if we get to theft, there's no person there, and there's no violence. When you get to simple robbery, you're adding a level of dangerousness, and you're adding a level of violence, because there's a person present at that crime, and there's a violent act that occurs, or a violent threat that occurs in that. And then when you get to aggravated robbery, now we're into the world of bodily harm or a dangerous weapon being used. So it is elevating the dangerousness and the violence involved in those crimes as you move forward from theft to
So the
simple.
position of the state of Minnesota is every purse snatching is a simple robbery?
At that point, you have a person present. You are taking that away from the person by force. So arguably, yes. Now, whether it's charged that way.
I'm not asking you what's arguable. I'm asking you if that's the state position.
Yes, that is the
Every
state's
purse snatching is a robbery.
Because at that point, you have a person presence and you have a use of violence by taking something off from somebody's person. And it increases the level of dangerousness, and it increases the level of violence from a theft crime.
But I think this comes down, this kind of raises the question that Ms. Townsend is raising, which is why isn't the language just say use of force, and saying instead of the legislature use more words than that, which is use of force to overcome or compel acquiescence?
Sure.
And so in the argument you're making, doesn't that, as the defense, as Ms. Townsend argues, make those words redundant?
No, it doesn't, because now we're getting deep in the weeds on the plain language analysis. So if you look at the plain language of this statute, overcome is to overcome. That's an adverbial infinitive. So the full infinitive of to overcome functions as the adverbial infinitive, and it's used to modify the previous verb, which is the uses of force. So and also if you look at if we're going very deep in the weeds, if you look at the dictionary definition of the word to, T-O, there's a lot of different definitions for that, but one of them is the word functions to indicate it is an infinitive. So if you take that as an infinitive and you're using that to modify, then it explains the use of force that is necessary in that situation.
But how are you overcoming resistance or compelling acquiescence in the purse snatching example? I mean, that's using force to take the purse, but doesn't that leave those other words, if that's a civil robbery, doesn't that leave those other words irrelevant?
Well, and it depends. So if the purse is just sitting next to the person, I think there's a different scenario between if the purse is sitting next to the person and somebody runs by and grabs it and runs away, versus if the purse is on somebody's body and somebody runs and takes it.
But what if they don't resist? What if the person just takes the briefcase? I mean, doesn't that beg the question of what resistance is? And
sure, but again, this gets to be victim focused, and if we get into the
go ahead, finish.
Sure, if we get into the victim focused analysis, then we're start asking questions: how strong was this victim? Was this because the strength of the victim is going to matter in that scenario? Because
but isn't that true? Like take murder as an example. The difference between attempted murder and murder: you shoot the same person, someone because of their physical nature is going to die. It's murder. They recover because, something happens. It's attempted murder.
Sure.
So that is very victim focused.
Well, if the person dies or not is a very clear answer to that. Of the person lives or the person dies, attempted or completed murder. With this situation, you have somebody carrying a briefcase, and if they're carrying a briefcase, depending on how strong they are, it's going to matter in terms of the analysis of whether the person can get away with it. Now, at least in the drafting of the statute, when you look at back to the plain language, it is whoever having knowledge. This is all defendant focused. This is about the defendant taking personal property in the presence of another, the defendant using or threatening imminent force, and then it's to overcome. So the to overcome gets back to describing the threat or the use of force. It's the amount of force that is involved. And the word to, according to style manuals, can mean in order to. So we're not adding words to the statute by interpreting it in the way that I'm advocating. To can mean in order to. But if we adopt Ms. Townsend's definition of overcome, to overcome, then we have to conjugate the word overcome differently. It would either be overcame, which is part of what the argument was today, overcame, which is not how the statute is written, or it would be written completely different, where you would say, add a comma and say, and overcomes the person's resistance. In either of those situations, then the appellant's argument is correct, that it is overcame, that there is an actual defeating of the victim involved. And overcomes, again, there's more of a defeating involved in that. But to overcome, again, can be in order to, which is, according to style manuals, at least style manuals that are around today and maybe not in 1963, but the style manuals today say to can mean in order to.
I recognize that both parties here argue that the statute is not ambiguous. So we wouldn't necessarily get to the 1963 committee comment, but I would be interested in your response nonetheless. I guess I get to ask irrelevant questions, and maybe this is an irrelevant question, but I would like your position on that committee comment. We heard the argument from opposing counsel that supports their view. Do you agree or disagree with that?
Well, I disagree with that, but I disagree with that the comment in general and taking the broader view supports that. Because one, if you look at what the jury instructions have done since then, and again, the jury instructions are advisory, they're not binding on this court, but the jury instructions support the argument that the state is making, which is these are the elements of simple robbery, and overcoming, defeating a victim in the circumstances isn't part of that analysis. And then looking at the context of how simple robbery fits within the other theft crimes also supports our argument. One thing that I would like to turn back to Justice Thiessen asked earlier is about the district court's specific findings in terms of the bottles. The district court did make findings of fact in the order, and that's at the addendum of page 1 and 2. And in paragraph 1 of the addendum 1 says, placed multiple bottles of liquor in her purse. Paragraph 2 is about bottles. Throughout the findings of fact, it's always in the plural of bottles. At the end, in the conclusion, is correct, where the district court said, took at least one bottle. Now, at that point, this is one bottle that was remaining, at least my reading of this, is one bottle was remaining in the purse because one had already fallen out and fell into the hallway and broke. So with the district court's finding, I think it is sufficient to find that there were multiple bottles involved.
Just to come back to the 30 or 50,000 foot level, whichever level we're at, altitude. So none of those cases, Solomon and the other, actually addressed this particular statutory argument, right? This is an unresolved issue. So even though they reached a particular conclusion, the facts look similar, they're not binding in how we interpret the words of the statute in this particular case.
Well, in terms of overcoming to overcome, that language was not directly interpreted in Solomon or Thornton or the baby formula case. I don't think any of those cases talked about to overcome. I think those cases, at a minimum, show that the court's not writing on a blank slate, that there is a lot of context already developed in which to address this question. At best, I think it does answer the question because there is that second in time where she had control and dominion over the personal property, if even for a few seconds. And that is in Solomon where that answers that question. So if you take the cases, the grammar, and the facts and apply the facts to this case, it's clear that the elements are met. Number one, Townsend knew that she was not entitled to the bottles. She admitted those were not hers. Number two, she took the personal property in the presence of another. Takes is the action. In this court has said Bowen is the personal property, and the clerk was present. Number three, she threatened and used force to overcome the resistance. This adds the violence. And the threat is both the mace and the threat of the bite, and the actual use of force is the attempted bite. And it overcame because the clerk at that one moment let go, and she had control and dominion over the property.
So have we ever had a case that actually addresses the question of whether you look at that single instance of time or whether you should look at the whole action in a sense of overcoming resistance? I think one of the arguments Ms. Townsend is making is even if it was for a few seconds, this was part of an entire action, and this clerk never really gave up.
Sure.
So do we have any, I mean...
That's the baby formula case. Which
is the Court of Appeals case?
It may have been, yeah. So within that case, yeah, they continued pursuit on that. With Solomon and Thon-Savin, with those two cases, those are situations where the court has clearly said, if only a few seconds. And Solomon is an interesting one because in this, Justice Anderson, this goes to your question, where confirmed or affirmed the attempted aggravated robbery. And with that, they said, but the facts of this case show that it was a completed aggravated robbery, but it also affirms the attempted. So in that instance, you had both attempted and completed.
But in
Solomon.
In those cases, anyway, it's been a couple days. In those cases, was there this situation though where it was completed and then there was another set of resistance in a sense?
Not in Solomon, for sure, because the robber at that point dropped the bag and dropped the gun because saw the police outside. I don't remember. Thon-Savin was about a motor vehicle theft. And the facts of that case were
Oh, they were just sitting there. They never really moved the car, right?
right,
Yeah.
right. So that's slightly different too. But in terms of those two cases, I don't know that there's that re-engagement that occurred in those cases, or at least I don't recall that occurring.
You're where I am too. My memory is not that good anymore. So.
But it's also interesting in Solomon, and Justice McCaig, this goes to your point, with the aggravated robbery that existed in there. There was bodily harm. This actually could have been charged as an aggravated robbery because there is evidence here of bodily harm. His shirt was ripped. His necklace was torn off. He sprained his ankle. This isn't a case of overcharging that it should have been theft or should have been attempted. This is a situation where they looked at these facts and charged simple robbery, which was correct and should be affirmed.
Is it the state's position that this case is about the taking element or the carrying away element?
Good question. It seems to have evolved since the Court of Appeals argument, and I didn't, and I said this in the brief, that it's not, I don't claim that they waived the argument that's before the court. I think the issue that is before the court now is the to overcome language.
But to overcome what? Taking or carrying away?
To overcome, well, it's the, I suppose it's to overcome the person's resistance of the taking and carrying away. But the to overcome is...
But the statute says taking or carrying away.
Correct. Right. So I think it's both in that situation, because she did take it, she did carry it away from the point where the bottle was on the shelf past the point of sale into the hallway where that initial scuffle started. So I think the to overcome goes both taking and carrying away. Unless the court has any other questions, we'd ask that you affirm.
I had just one quick question. You're not claiming that Townsend can be responsible for the fact that the other person took bottles from the liquor store?
No, this wasn't an aiding and abetting charge. In hindsight, I think it probably should have been. It wasn't, because that person clearly got away with bottles, and Townsend's use of force assisted and aided in that person getting away, but that was not the charge that was brought. I dropped a footnote. I think that adds context to the entire situation that was occurring.
But we're not considering it.
Correct.
Because it wasn't charged.
That's right.
Yep.
Okay, I think we're good. Thank you, counsel. Ms. Nelson, you have 5 minutes for rebuttal.
Okay, just a few comments. I'd like to address Chief Justice Gilday's hypothetical about what if after Townsend threatened to bite the store clerk and he let go, that she just stayed there and didn't move. So the state says that that would still be a simple robbery. That's not true, because she'd already taken the bottle off the shelf. She needs to use the force or threat of force in the taking or carrying away. Taking's already happened, so we're not talking about taking. We're talking about carrying away at that point. She's in the process of carrying away, but she doesn't. She gets stopped, threatens to bite the clerk. At that point, that wouldn't be a completed simple robbery unless she continued to move and he completely acquiesced and didn't re-engage. He re-engages her. Therefore, we have an attempted simple robbery.
Counsel, it's not really a taking until you walk out of the store, is it?
No, it is a taking as soon as she took it off of the shelf and put it in her purse. That was a theft.
But a regular shopper may put something in a bag and then eventually make her way to the counter to pay for it.
Correct, but she had the intention. With the theft statute, you have to have the intention of taking something and depriving the person of it.
So you're conceding the theft occurred the moment she took it off the shelf and put it in her.
That was a theft. But it wasn't a simple robbery because there was no force used. Okay? So, but when we start to talk about what if she moved a foot or she did this during the altercation, I think that goes to show how crazy this can get when we start to slice and dice a ongoing event like this. And one of the other issues that seems to be coming up a lot, again, is whether or not we need to focus on what happens to the victim. Well, we do, because that's what the statute says. What happens? What was the effect of the force? Did it overcome? Did it compel acquiescence? That's what the statute says. That's why we focus on it. What was the effect of the force on the victim?
Well,
I'm going to take Justice Lillehog's hypothetical.
Mm-hmm.
I'm not sure if that's a simple robbery or not, but I'm going to ask you, what about his conclusion, and I think the admission from opposing counsel that all purse snatchings are now simple robbery? Is that a problem?
I think it certainly can be, yes, because it depends on, again, the facts of the case. What happened with the purse snatching? You use force to pull it away? If you did, and you use force to take it, and taking can be a short time, then yes, that would be a simple robbery. But if the purse was sitting by somebody and they just picked it up, then that would not be a simple robbery. There was no force used.
Counsel, I want to go back to what I think I heard you say, and to me, it almost sounds like you think it needs to be a continuous compelling or acquiescence. And I don't see that, when I look at the statute, I don't see that they have to continuously compel acquiescence. And that's why I'm having trouble with your argument against in the moment when there was the threatened bite and they let go. Because if I understand you correctly, and please tell me if I'm wrong, it seems that you are saying that there has to be some sort of continuous action to the point of conclusion in carrying out the crime.
Not exactly. I understand what your argument is or what your thoughts on that are, but it has to at least be a person's passive assent or acceptance to, not just in general, but to the carrying away. And that didn't happen here. There was no passive assent or acceptance to the carrying away. He recoiled. That's not necessarily compelling acquiescence.
So, counsel, let me change the facts a little bit. Let's say your client starts walking away with the bottle, the manager confronts her, and then she pulls out a jackknife and says, if you don't allow me to go, I will stab you. And at that point, do we have a simple robbery?
Does he let her go?
That's my next question. He says, your jackknife doesn't scare me because I've got a Colt 45 here. So because he has a Colt 45, does that mean there's been no robbery?
If he hasn't consented or assented to her carrying away the property, yeah. There's an attempted simple robbery, but not a simple robbery, because it's not enough just to use force. And that's what this keeps coming down to.
Your point is it's not enough to use force, it has to work. The force has to work.
It has to work, because otherwise all that language is superfluous and doesn't mean anything. Why not just get rid of it then? Why not just make it the robber used force?
Well, and not only
care what happened.
Not only has to succeed, but I mean, it really turns on kind of when that happens, right? So you're saying that here the clerk never gave up throughout the whole course of the thing, and that's what's really important here, that you can't parse like one part of the struggle with the other part of the struggle.
Chief Justice, I'm out of time. May I take a moment to answer?
Please answer the question, yes.
Thank you. Absolutely, Your Honor. You cannot parse this through so carefully. It has to be looking at the entire event.
Because the clerk here never gave up.
Because the clerk never gave up, and we know the clerk never gave up because the clerk said he didn't give up. He was not going to give up till he got those bottles back.
And is there any case law, similar to the question I asked Mr. Schmidt, is there any case law where we've decided that one way or another?
No, that's
okay.
What you get to do today.
Yeah, okay.
Thank you very much. We do ask that you reverse Townsend's conviction. Thank you.
Thank you, counsel. Thanks to both counsel for the help you provided to the court in this case. This matter is submitted. We'll issue an opinion in due course. We're going to step off the, I was going to say bench, but the stage, take off our robes, and then we'll come back out and talk with the students. But before we do that, please, I would ask everybody to join me in thanking the lawyers for coming on this roadshow with us. We appreciate it so much, counsel. Thank you. Okay, we're adjourned. We'll be right back.
right, thank you very much for your attention during the arguments. It's greatly appreciated by everyone. We have a few thank yous to give. First of all, I would like to also thank, they're not on the list, but I would like to thank on behalf of not only myself, but on the Supreme Court and everyone here today, the work of the Martin County Sheriff's Office, officers who are here, and the Fairmont Police Department as well. Thank you very much. I would also like to thank members of the Planning Committee who are organized and executed this wonderful event. They are Donna Holstein, former mayor of Fairmont and Planning Committee co-chair, Martin County Attorney Terry Wieselman, Planning Committee co-chair, Fairmont Senior Junior High School Principal Jake Teege, Superintendent Joe Brown of the Fairmont Schools, Martin County Sheriff Jeff Marquardt, Fairmont Police Chief Michael Hunter, Corey Clanderud, who is the Martin County Sheriff's Office Chief Deputy, School Board President Rufus Rodriguez, Fairmont High School staff Mark Borkart, Teresa Keel, Jeff Nauman, Gene Garbers, Jared Thompson, Brad Johnson, Bob Bonine, Bruce and Shelley Abbotts from Gemini Studios. I would also like to recognize State Court Administrator Jeff Shorba. We give many thanks to the attorneys who volunteered their time to visit classrooms and prepare students for these events. We are grateful to the Fairmont VFW members Post 1222 and American Legion Post 36 who were flag bearers this morning. Again, many thanks to the Fairmont Police Department and Sheriff's Office who were providing security today. We thank Gemini Studios and the Fairmont School District for making this live online broadcast available to Fairmont community and surrounding areas. Finally, thanks to all of you for participating in this special event. Now, this is where the fun stuff begins. You'll be allowed, the justices will soon return to the stage to answer questions after they introduce themselves briefly. If you have a question, line up at a microphone and the Chief Justice will call on you. Please remember that the justices are absolutely prohibited from discussing the case you just heard, or any case currently before their courts. If they were to talk about it, their comments would be interpreted as not being neutral, and either the appellant or the respondent might think they are being treated unfairly. But there are a lot of questions you can ask about their background, experience on the court, etc. So now, please welcome back the justices of the Minnesota Supreme Court.
You guys did great. I was hoping for a better reaction. All right, so here's the drill. We will briefly introduce ourselves to you, and then we hope you have questions for us. And if you don't have questions for us, we'll just start asking you questions. Are you guys awake? I'm funny. That's better. Okay.
We didn't laugh either.
I know, I roll, I roll, I roll. All right, so I'm Lori Gilday. I'm the Chief Justice. I've been the Chief Justice since July of 2010. I've been on the court since January of 2006. I was briefly on the trial court before coming to the Supreme Court, and I was a lawyer for about 20 years, practicing in all kinds of courtroom work before becoming a judge. We're delighted to be here in Fairmont, and thanks. You guys really were a really, really good audience. Justice Anderson.
Good morning. I am a 1973 graduate of Mankato High School, then Gustavus Adolphus College and University of Minnesota Law School. I practiced in Fairmont for 4 years, 1979-1983, with what was then known as the Erickson Law Firm, named after a famous, well-known lawyer, also elected to the Minnesota legislature. I practiced then in Hutchinson, went to the Court of Appeals and then the Supreme Court, and my other connection to the Martin, Jackson, and Faribault County area is I am married to the former Truman High School band director. So I'm delighted, we were delighted to be here last night and delighted to be here this morning.
My name is David Lillehaug. I grew up in Sioux Falls, South Dakota, which I consider greater Minnesota. Not that far from here. Went to Augustana College and then Harvard Law School. Practiced law for about 25 years, including as United States Attorney for Minnesota, the federal government's chief prosecutor in the state. I've been on the court since 2013.
I'm Natalie Hudson. I'm originally from Missouri, but my family moved here to the Twin Cities in 1968, so this is pretty much home. I went to Mounds View High School, then I went to Arizona State University, returned home, and went to the University of Minnesota Law School. I practiced law for about 23 years, mostly in the public sector. I was a legal aid attorney for many years. My last 8 years before becoming a judge, I worked at the Attorney General's office doing appellate work, basically doing what you saw the attorneys here today doing. I was on the Court of Appeals, which is our intermediate court, for 13 years, and I've been here on the Supreme Court since November of 2015.
Hi, I'm Margaret Chudich. I grew up in Anoka, Minnesota, the Halloween capital of the world, coming right up. I got my undergraduate degree from the University of Minnesota and my law school degree from the University of Michigan. I've been on the court about 3.5 years now. I was on the Court of Appeals for 4 years before that, worked in mainly the public sector, a lot of time as a prosecutor during my legal career.
Good morning, I'm Ann McKegg. Hello, up yonder. Thank you. Wanted to see if you're all paying attention. I am from the Leech Lake Reservation in northern Minnesota, Federal Dam. For those of you who are fishermen, I would expect you to know where that is. Population 106. I went to Northland Reamer High School, then to St. Catherine's University in St. Paul, then to Hamlin University School of Law, and then I was a county attorney where I worked with abused and neglected children for 16 years. And then on to the district court bench, and then in September of 2016, I was appointed as the first Native American female in all of the United States onto our state's highest court.
Hi, so I'm Paul Thiessen, and I'm the most recent Supreme Court Justice. I was appointed in the spring of 2018, so about 1.5 years, which is why I always get to go last. I grew up in Bloomington, Minnesota, and went to Harvard and went to law school at the University of Chicago and then moved back here. I worked as a public defender and as a civil litigator at a law firm. I also served 16 years in the state legislature, including a couple of years as Speaker of the House. And I'm thrilled to be here, and I hope we have some really great questions.
Okay, so questions? There's microphones down here, there, and there. So just come on, step up. Somebody has to be first. Go ahead. Here, we've got a brave person right here. Step up to the microphone.
Hi, I'm Brooke, and I was wondering what was the most interesting case you had? It could be because of the situation. It could be because it was just kind of funny. So what would you say?
So I get this question often, and it is actually a great question. Over the course of many years, you hear some cases, some are more interesting than others. My favorite is a case that I wrote the opinion on, sat on, when I was at the Court of Appeals, not the Supreme Court, and it involved a dispute about whether or not in the case of a broken engagement, did the man have to give the woman the engagement ring, or did the woman have to give the man back the engagement ring from the failed engagement? And surprisingly enough, in this era of gender equality, all of the women think that it was a gift and she gets to keep the ring, and all of the men think it's a broken contract and he gets the ring back. I'm here to tell you the courts in the United States were divided on this important question, and we ultimately ruled she got to retain the ring. So there you go.
Okay, you come on up. You should, let's have a couple people in line here so we can keep this moving. We got lots of people who want to ask questions, I'm sure, and I'll just alternate back and forth. So you get to go next.
What's your stance on the Second Amendment?
So, do you want to take? So he asked, the question was, what's your stance on the Second Amendment?
The Second Amendment says militia being necessary to freedom, the right to keep and bear arms will not be infringed. Our stance on the Second Amendment is whatever the United States Supreme Court says about the Second Amendment. So for many years, the U.S. Supreme Court said it's about militias. It's not about the personal possession of firearms. That changed about 10 years ago in a case called Heller. And now I understand that the Supreme Court may be taking another case involving the Second Amendment. We've applied the U.S. Supreme Court's law on the Second Amendment, and will continue to do so.
Here, go ahead.
If you guys were working on a murder case, and let's say the guy that was the murderer, and you guys were going to sentence him to like life imprisonment, and then he freaked out and hurt someone, what would you guys do about it?
So he's asking, I think, a question about if a defendant is accused of committing first-degree murder and then he's being sentenced, and as part of the sentencing hearing, the defendant commits another act of violence, is very upset about the sentence, and commits another act of violence against someone in the courtroom, maybe? So that's a really good question, and it illustrates kind of the difference between being a district court judge and being a Supreme Court justice. So at our level, we don't sentence people. Judge T is the one, that happens in his courtroom. That's where the witnesses come, that's where the juries are, that's where the facts are found. At our level, we are reviewing legal questions. So was the sentence imposed legal? Was a crime committed under the statutory elements that the legislature has given to us? So that situation wouldn't happen at our court, but that might be something that Judge T would have to confront. Yes?
Does your job ever get, like, stressful?
She asked, does our job ever get stressful? Yes, it does, like most people's jobs. You know, the types of cases we hear are very serious cases. We hear everything from, you know, zoning matters to first-degree murder cases. And sometimes the facts are, in the murder cases, for instance, are rather gruesome and they're serious, or other times we're hearing family law matters where people's children are maybe being taken from them. And so they can be stressful. The workload is heavy. There's a lot of reading. There's a lot of writing. But it's a job that I know we all enjoy, and you find ways to deal with the stress as you should in any job, in terms of whether you're doing exercise or you find other outlets, things that you enjoy doing, things that take your mind off or take your mind away from the seriousness of the endeavor that you're involved in. So yes, it can be stressful, but you find ways to deal with that.
I know you just said that you deal with mostly serious cases, but have you ever had a case that was ridiculous and made you laugh a lot, or made it hard to keep a straight face during the trial?
You know, I served on the Court of Appeals for 4 years, and this court, so 3.5 years, so in those almost 8 years, I don't think I've had a case like that. I mean, there are cases where some of the facts are funny. You know, you hear some of those cases when they talk about defendants who do dumb things, you know, like steal their neighbor's property and then have a yard sale. I mean, that kind of thing. So it does happen, but most of my cases have been not like that.
How much do you get paid?
First of all, I like your hair.
Thank you.
It's a very awesome color. I'm thinking maybe I should do that this evening. We make, I think, about $186,000, which sounds like a lot. And you're all going to go, oh my gosh, that's a lot of money. But I'm here to tell you it doesn't matter. You still live paycheck to paycheck.
What made all of you enter the law field?
Good question. Sometimes, so the question is what made us become lawyers, I guess. You know, I suppose partly grew up, you know, thinking about it. I was always interested in kind of the public policy stuff and and seeing lawyers on TV. You know, I just thought it would be an interesting job. I think the thing that is best about the job that I like, I mean, two things, and particularly about this job. One is you get to think about a lot of different stuff, you know, so it's not the same all the time, and it's pretty intellectually challenging that way. And the other thing is you get to see kind of the whole spectrum of how people behave in the world. And that keeps it really interesting, too, because people do, as Justice Chudich said, some really crazy things sometimes.
Go ahead, right here.
What's the most common type of violence that you go through?
what's the most common type of violence that we see in our cases? You know, I don't know that there is one type of violence that's more common than another in terms of the cases that we see. I don't know, Justice Anderson, do you?
Original jurisdiction. Yeah, so the way I would answer that question is to say that one of the unique features of the way we handle under our Constitution and state law murder cases, first-degree murder cases go direct from Judge Tuschinski's court to the district courts to the Supreme Court. So we've got a fairly heavy docket of the most serious crimes of violence that Minnesota law recognizes. And those are, I will tell you, those are I think the most difficult cases we handle, because you deal with the human wreckage that is left behind the most violent acts that men and women can commit. So that's a part of it.
So if the statutes in a a law change, what happens to previous cases that were convicted on those charges? Like, are they reopened? Are they just dismissed?
That's a great question. Of course, you can only be charged with a crime if you commit the crime at the time the law says it's a crime. So when the law changes and becomes more strict, you can't charge people for a bunch of past acts. But what about those cases where someone is charged and convicted and then the law changes and becomes more liberal? Then it's a pretty complicated question, depending on what the law is, as to whether the effect of the new law is retroactive or not. So you asked a really complicated question, and I can't answer it because it depends on the case.
What's the highest offense somebody could get?
What's the highest offense someone can get? I think being charged with, the highest sentence, in Minnesota would be life without the possibility of parole for first-degree murder. We don't have the death sentence here in Minnesota, as some states do, but if you commit first-degree, which is premeditated, it has to be premeditated to be first-degree murder. If you commit that and you're found guilty, in Minnesota, that's life without the possibility of parole.
How would somebody get, appointed to become on the Supreme Court?
We have what's called a Judicial Selection Commission in Minnesota, and the governors, the past governor, Governor Dayton, and I think this governor is probably going to use that Judicial Selection Commission. So people like ourselves who want to be on the court will apply, and it's an application process. We get letters of recommendation from people. Grilled by a 13-member committee, and they really look into your background greatly. They ask you a lot of questions, and then they send 2 or 3 candidates to the governor for the final choice, and then you get grilled again by the governor and their people. So it's kind of a process. There's another way of judges. Once we've been appointed, we need to run for election, and we have 6-year terms, and sometimes justices will serve on those 6-year terms until their term is up, and then it goes straight to the people for election. So that's another way that people can get to become justices on the court. Typically, though, it goes through the appointment process because a justice will leave early.
Your Honors, do you often create scenarios or examples that interpret the context of the case? For example, the briefcase and the finger gun scenario?
If you are Justice Lillehog, yes.
Have you ever had a case that's felt personal to you?
So have we ever had a case? So I'm pretty new. I guess the most, one that was personal, recently we had a case that we decided about. Some parents had complained about a basketball coach, and the basketball coach sued for defamation, saying that what the parents were saying was not true. And so we had to decide some legal issues around that. But now, having been a parent of high school athletes for several years, I got a little bit nervous because I have complained in the past about basketball coaches. So that one got a little bit close, I guess, yes.
We just found that out.
Have you ever feared that you made the wrong choice with a case?
So the question is, do you ever feel that you've made the wrong choice? You know, I think you decide the case that's in front of you and then you move on. And you hope that you've got it right. We spend a lot of time trying to get it right. It is statistically likely. You know, I've been a judge now 20 years, 6 years on the Court of Appeals, 15 on the Supreme Court. It's statistically likely that I've made a mistake because it's part of the human condition. But you work very hard to try to minimize those occurrences, and you try to make the best call you can under the circumstances. And it's one of the reasons that our system is set up, you know, with a separation of powers, with the various branches of government checking each other. It's a deliberate process. You try to, all of those things go into constructing a system that you try to have as few errors as possible. But does it occur? Sure.
Would you recommend trying to get this job?
Would I recommend you trying to become a Supreme Court justice?
No, anyone in general.
Recommend it to anyone?
Yeah.
Absolutely. I mean, if you're a lawyer, you got to be a lawyer to do this. But I love my work on the Minnesota Supreme Court. The cases are interesting. The lawyers who argue before us are generally very good. And you know, but what really makes me tick in this job is the idea that we're the court of last resort for Minnesota. So unless the legislature changes the law, we're the last word on the law of the state of Minnesota. You can have a real impact on the law and on society that way.
Have you ever gotten to hang out with Obama?
That comes to me. No, I wish I know. I wish I would have had that opportunity. I've never had the chance to do that though.
I was wondering if you've ever received threats due to what was going on in a case.
I'm happy to say the question was, have we ever received threats for what's gone on in a case? And I'm happy to say that I personally have never. And I don't know that our court has in the time that I've been on it. There were colleagues at the Court of Appeals who did receive threats about certain cases, and that was sobering to see.
What's the longest session you've ever had?
So the oral argument that you saw today is very typical. Our oral arguments usually last about an hour. If your question is about how long does a case take from beginning to end at the Supreme Court, generally we issue our opinions within 3 to 5 months of the oral argument date. Sometimes the cases take a little bit longer than that. If many of us are writing, oftentimes there's just one person writing for the court and we're unanimous. We're unanimous more than we're not. But sometimes it happens that we have separate writings. Maybe you disagree and you write a dissent. So then the case can take a little bit longer for us to get our decision out. Over here.
Each of us has bias based on prior experiences, beliefs, and morals. How does this impact your decision making?
Every day, but we try really hard not to, and that's why it's great that there's 7 of us, because we kind of help keep each other in check when it comes to that, because there's really no place for that when it comes to our decisions.
Okay.
What's all of the judges' favorite colors?
Favorite color? Oh, I mean, for me, it's turquoise. Go ahead.
What's your hardest part of your job?
The hardest part. What's the hardest part of the job, Justice Thiessen?
Well, first of all, my answer would be green to the last question. So, that wasn't the hardest part of my job. I think the hardest part of the job for me so far, 2 things. One has been trying, the cases are, you know, I said I like that they're so different, but because they're so different, many times I have never dealt with the particular issue we're facing, and so kind of have to learn the whole thing from the bottom up, and so that can be challenging as well. And then the second thing is the thing that Justice Lillehog talked about, is the worry about how we not just decide a particular case, but how we reason it, the reasons we give for it, because they could be law 50, 100 years from now, and dealing with issues that we can't possibly anticipate today. So really trying to think, okay, it's maybe an easy decision in this case, but what are the consequences for future cases? That I worry about a lot.
Reach this. All right. So grammar. How did you guys did you guys just get up here and be like, oh no, grammar?
We love grammar. Oh. And I'm not going to talk about this case in specific, but the legislature has actually given us rules that help us interpret statutes that the legislature has written. And one of those rules says that we should look for the rules of grammar when we're trying to interpret the words the legislature has written. So it's part of the job. So to all you out there who are resisting your English teachers on grammar, stop resisting, learn the rules. Okay.
Have you ever dealt with a case that deals with double jeopardy? And if so, how did you do that?
So you're asking about double jeopardy. For those of you who, that's an interesting philosophical question. I can't say that I recall specifically having had that issue, but I can tell you just one quick story. We have a constitutional protection against double jeopardy. Can't be prosecuted twice for the same crime. There are lots of civilized places in the world that don't have that rule. And I had an opportunity to visit once with a French jurist who was asking me, well, what happens if the prosecution tries a case and the jury finds the defendant not guilty? And I mean, does the state appeal that? That's a perfectly reasonable question to ask under his system of law. In our system of law, it's not a reasonable question because the prosecution generally doesn't have a right to appeal. It's protected by the Bill of Rights. It's one of the Bill of Rights attached to the United States Constitution, and there's a similar provision in the Minnesota Constitution.
Has anyone ever tried to bribe you?
No, and they better not.
Have there ever been any, like, pets like a dog or a cat in court?
I was going to say, we've had cases that involve pets, but we've never had an instance where a pet or a dog or a cat or anything has actually been in court. Chief?
We had a law clerk a few years ago who had a service dog, and so he took his service dog everywhere, and everybody got to love the dog. I can't remember his name, but that's the only context in which I've seen a pet. Was his name Piper? Okay. All right, over here.
How do you deal with, like, personally, if you feel sorry for the person? How do you deal with that?
You know, that happens a lot, that I might feel sorry for people in our cases. And I think it's good to remember that these are real people and they have real backgrounds in that. But we have to try not to let that sympathy for a person counter what the law requires of us to do. So sometimes when I write opinions, I might put in a line that recognizes that this is really a hard thing for that person, but the law requires us to do something else.
What has been the hardest case you've had to close?
The hardest case I've had to close? I just think any hard case that has to deal with children and what happens to children is a tough case.
Can the Central Intelligence Agency be punished for the human experiments it ran on American citizens in projects such as MK Ultra and Operation Mockingbird?
All right. Well, that really struck a nerve. Thank you. So, first of all, I want to go on record saying I do not love grammar. So, you still have to learn it, but I'll admit that. So, those kind of cases typically, I'm going to dodge the question. I'll just let you know up front. But those kind of cases typically would not go to our state court system. So, we deal with Minnesota state laws. And if you're dealing with the CIA and issues relating to that, it would very likely to go to federal courts. You know, so we have two different systems of judicial systems, and the federal courts would have to deal with that, and I would think thankfully in this case.
Go ahead.
Is there any like U.S. Supreme Court case, like historically, that you'd want to see like overturned? Like I know, for example, there's like a bit of controversy around like Korematsu versus the United States.
So the question is, are there any United States Supreme Court cases that we would like to see overturned? We generally stay out of the business of advising the United States Supreme Court what they should do with their jurisprudence, and for the most part, they stay out of advising us what to do about, you know, uniquely, for example, Minnesota constitutional issues. I think you could get any member of this panel to identify some decisions that are clearly wrong, and I think that's a conversation worth having, but we're probably not going to have it here.
Do people look at you guys differently because you're on the Supreme Court?
Well, lawyers do tend to laugh at judges' jokes more than they would before they became judges. I think when you become a high-ranking public official of any sort, People look at you a little differently. They expect accountability. They expect transparency. I think you're held to a higher standard, and properly so. For judges, we have what's called the Code of Judicial Conduct that lays out the ethical expectations that we have of all judges.
Have you guys ever known anybody who has either been like demoted or removed from the Supreme Court?
From our Supreme Court, I don't think there's been anyone, Chief, but I don't know. I don't believe so.
What is the most debated topic that you get in the Supreme Court? Debated topic.
I think maybe First Amendment cases, defamation, those kinds of things. We have a lot of debate about those, but we have many topics that come before us.
So I've got a complicated one. So say someone is trying to kill someone and they fail, but the victim has a heart attack right there from the stress and dies. Would that still count as first-degree murder?
We don't give advisory opinions.
If you were to get a case in which you believe some of the pieces are missing, would you be able to request that the police department involved look at the case again?
That's a really good question, and can be frustrating at times, but the answer is no. So when we review a case, only the stuff that goes on at the district court level is included in the record, and we're limited to that. So, but you raise a really good question, because a lot of times there's unanswered questions that come to mind, and you kind of have to put those aside and just look at what was introduced at trial. We're stuck with that.
Go ahead.
This is a question about your placement in society. Like, let's say the difference between like someone, just your average person being killed versus someone like the president being killed. Would the charges, and it still happen the same way, would the charging for the assassination of the president be higher than the average person? Or like anyone else that's kind of higher up?
So the question has to do about what happens with varying kinds of fact circumstances when there's a serious felony, for example, murder. You look to the legislature to define the crime. And so the crime of attempted assassination of elected officials, including the President of the United States, is defined differently in different places. So the answer to your question is you look to the statute that the legislature or the Congress has adopted. The Congress has the power to make those decisions. In terms of the enforcement of the law, we hope that that enforcement is relatively equal across classes and segments of society. There's an argument about whether or not it is or is not, and that's a debate that all citizens get to have in terms of the way the statutes are drafted and the way those laws are enforced. That's a conversation you as citizens get to participate in.
How many cases do you get in a year?
How many cases do we get a year? We actually take a look at about 800 cases a year as to whether to take them. We end up taking and issuing full opinions in about 100 to 125 cases per year. So that means we have like 10 or 11 arguments like this one every month.
Has social media affected the way you have cases? Like, do you get more cases due to social media?
I think she's asking, do we get more cases due to social media? I don't know that we get more, but we certainly are beginning to see cases where social media is involved, just because that's how our society has evolved. Like some of the defamation cases, as Justice Chudich mentioned, sometimes the defamation is happening on Facebook or on Twitter, and so the social media has come into our case law. But the law is still the same. You still look at, say, defamation and the law of defamation in the same way. It's just that it's coming to you in a different media.
Have you ever had to make a decision in court that goes against your personal beliefs or morals?
Yes. We have to do that from time to time. We have to decide the case. I might think the legislature has enacted kind of a dumb law, but it's not up to me. And if the language is clear, then we do have to enforce that.
You guys ever hang out outside of work?
Do we ever hang out outside of work? No. I mean, would you want? No, okay. No, we do. Last night, actually, we hung out a little bit and had a good time. So we spent a lot of time together.
What do you guys think of AI working with law enforcement? What do you guys think of AI working with law enforcement?
What do we think of AI working with law enforcement?
Well, I don't know that I can particularly answer that question because we probably are going to get more and more cases about that. But it is a big issue that's arising. Kind of what are the rules? It's one area where the legislature really hasn't defined the rules as much as they probably are going to need to. And when that happens, we'll look to the legislature. But until then, those privacy issues and AI raise a lot of questions.
Okay, I'm being told we have 5 minutes, so let's do a lightning round. Go ahead.
How often do you have people fall asleep in court?
How often do we have people fall asleep in court? I only remember one time, and it wasn't a person involved in the case. It was somebody there who was observing. Go ahead.
What determines what kind of cases you deny?
What determines what kind of cases we deny?
We have a rule that sets out the cases that we should accept, and we try to apply that rule. We meet twice a month to do so, and it includes factors like, is this a question where the courts below are divided? Is it a question we haven't decided recently? And it is a question of importance to the people of the state of Minnesota.
If someone were sentenced to a year in prison and they went to you guys and that process took about like 5 or 6 months, would they begin their year in prison after you guys made your decision, or as soon as they received that sentencing?
It depends. The answer is it depends. It depends what the district court judge has done in terms of ordering the execution of the sentence. We do sometimes have cases where we're going to reverse a conviction, and if we dawdle too long, somebody will have already served their sentence. So sometimes we'll just issue an order releasing the person from incarceration or directing that be done, and then our full opinion comes later.
A friend of mine wanted to know what you guys' favorite food is.
Favorite food? Oh, yeah, my favorite food. I'm blanking. Well, that.
What do you feel about the removal of Civil War monuments and the Confederate flag?
Personally, is this a question that Margaret Chudich gets to answer personally? Okay, I'm not answering it personally. You can see me after we're done.
What is the coolest opportunity that you have had since being on the Supreme Court?
Coming to schools like yours.
Go ahead.
What made you guys actually want to be a part of the Supreme Court and not stay as a lawyer or something else?
I think the chance to be able to be hopefully a role model or an inspiration for somebody like ourselves to want to do this in the future.
Okay.
What would happen if somebody started just like throwing punches mid-session?
We would have them removed. Go ahead.
Oh, if you could dye your hair any color, what would it be?
Seriously?
Yeah.
The color I have. Go ahead.
When you were children, was this a job you always imagined you'd have?
No. No. And in fact, it wasn't a job that I thought I would have until I applied. So.
Go ahead.
My friend Braden wants to know if you guys have any specific dress codes.
Because I'm not wearing the right dress code today. But I'll tell you what happened is I forgot my suit at home when I left. So I went to Walmart. So this is from the Fairmont Walmart.
Wow.
Has anyone ever tried to like make you guys feel sorry for them?
Has anyone ever tried to make us feel sorry for them? I mean, sometimes it comes up in the briefing, as Justice Chudich was talking about earlier. I mean, some of the cases can be really sympathetic.
Let me answer that question. We do see occasionally lawyers who will try to influence the court based on sympathetic facts, or they'll introduce the parties. They can do that. There's nothing wrong with that. But it's not very effective. I mean, all of us have a trial background in one sense or another. Those arguments are typically made to juries. We're dealing with legal issues. And so we understand that there are real losses, real problems here, but we focus on the legal issues.
Have you ever been threatened because a case didn't work the way they wanted it to work?
I did get something at my home. It turned out not to be anything scary, but I thought it was going to be scary because it was from a defendant who had been found guilty when I was on the district court. But law enforcement took care of it, and it didn't end up being a problem for me. Go ahead.
Have you had any cases on stolen vehicles in the Supreme Court?
Stolen vehicles.
Before I answer the question, I want to give a shout out to the guides that have been assigned to each of the justices today. They come from the Fairmont High School mock trial team, which last year qualified for the state tournament for the first time. So thank you. Yeah, a couple of years ago we had a case from Worthington involving an allegedly stolen vehicle where the question was, if a guy's passed out in the car and the car's running and the doors are locked, it's somebody else's car, did he steal the vehicle? And we said that it did qualify as a stolen vehicle under Minnesota law.
Go ahead.
If you weren't in the Supreme Court, what job would you have?
I think I'd be a veterinarian. I love animals. I'd be a vet. And I like pizza. Somebody asked that before. I like pizza.
Are there any items that are not allowed in court? Like, if someone has that item, they can't use it as evidence?
I think if it's involved in the case in some way, we probably would let it in the court. We have rules for the people who come to watch our cases, but I think we would let in all relevant evidence as long as it's not super dangerous.
Okay, so that ends our time. You guys have been a great audience. Thanks so much for all your questions.
Thank you, Justices. This was an awesome experience. Students, have a seat. I would like to thank you. You have been a tremendous audience on behalf of the 7 schools represented here and the administration from those 7 schools. Thank you. This was awesome. You've been an incredible audience today.